SJC-12883, Christopher P. Kauders, v. Uber Technologies, Inc.
Ms. Ellsworth.
Good morning, and may it please the court. There are two fundamental flaws in the Superior Court's decision, one procedural and one substantive, both of which require reversal. Briefly, on the procedural point, the Arbitration Act allows a party to challenge whether an agreement to arbitrate exists only once, either in opposing a motion to compel at the outset of a case, or after an arbitration award has been issued in a motion to vacate that arbitration award. The Kauders here chose the former route, and the Superior Court was without jurisdiction or authority to reconsider his prior ruling compelling arbitration after an arbitrator had issued an award in Uber's favor and after Uber had filed a motion to confirm that award. A motion for reconsideration can't be used to circumvent the requirements of Chapter 251, including the strictly enforced 30-day limit for moving to vacate. On the substance, as to the question whether the Kauders entered a binding contract with Uber, the answer to that question is unequivocally yes. Many other courts, including in New York, California, Illinois, and Texas, have concluded that Uber's registration process provides reasonable notice to users that by creating an Uber account, they are agreeing to Uber's terms and conditions. The First Circuit's decision in Cullinane is an outlier relied upon by the Superior Court, and it's inconsistent with this great weight of authority. It imposes a conspicuousness standard found nowhere in Massachusetts law of contract formation, and it fails to consider the Uber registration process through the lens of the reasonable user, who is a consumer using a smartphone to engage in an online commercial transaction. The Uber registration process is straightforward. It consists of 3 screens, all of which must be completed to create an account. The third and final screen contains only 24 words, all visible without scrolling on a single screen, and it provides a notice of the terms and conditions that is bolded in the center of the screen, in different color font, in large font, and emphasized by a surrounding box indicating a clickable link. This single uncluttered screen reasonably communicated to the Kauders and any other reasonable user that by creating an Uber account, they were doing so subject to Uber's terms and conditions. And it provided clear notice of how to review the terms in the same way that notice has been provided of the terms of paper contracts throughout time. Uber's registration process also requires users to make an affirmative act of acknowledgement, notifying users that by creating an account, by completing the registration process and clicking done, they are doing so and agreeing to be subject to these terms. The vast majority of courts. Yes.
So may I ask you, can we go back for a minute to the 30-day issue, the procedural rule?
Yes.
And my question there is, if you look at 251 section 12, is that what you're relying on with regard to the 30-day rule?
Well, yes, Your Honor, it's section 12, and in particular, it states that an award will be confirmed upon motion unless a timely motion has been otherwise filed to vacate. And here, there's no question that a motion to vacate was not filed within 30 days.
Okay, and then it lists in subsection A that it says the court shall vacate if, and then it says it has 4, I think that's what the judge cited anyway, 4 subsections in his decision. And what my question is if we conclude that actually there was no valid arbitration agreement, in fact, and that arbitration shouldn't have occurred in the first place, how does any of this apply?
Well, if I understand the question, Your Honor, if this court were to conclude that no valid arbitration agreement existed, that option or the ability to raise that argument to the court was available to the plaintiffs by simply appealing a confirmation of the award. So Uber moved to confirm the award, and the Superior Court indicated had no choice.
When you move to confirm the award, the judge could confirm it, or he could not confirm it, correct?
He could. I don't think he had a basis to vacate it on the grounds that the Kauders have raised here, which is the lack of an agreement to arbitrate. Section 12A5 indicates that can be a ground to vacate an award only if a prior motion has not already been brought pursuant to Section 2 along those lines. So it's an either or.
Okay, let me move back to the substance for a moment before I release you to the other judges. And one of my questions is, when you signed in here, when you created your Zoom account, do you know what terms you agreed to?
Do I know what terms I agreed to? I do not, Your Honor.
We don't know if any of us signed on to an arbitration agreement right now.
Well, I think if I recall, when I registered for Zoom back in the day, I was probably put on reasonable notice that there were terms that applied, and had I...
You don't remember what they are or have any idea what they are.
No, and there's no requirement, as Your Honor is well aware, that anybody have actually reviewed the terms of a contract to be bound by it. So that is likely commonplace and may be the case here. That doesn't defeat the contract formation at all. It's
Yeah, I guess, you know, when I think about these, I understand these click wrap and browse wrap and all of this stuff is just everywhere, and we all do it. I do it constantly. I agree to all sorts of things I probably shouldn't agree to. But then I go back in my head and I think about contracts of adhesion when in contract law in law school, and I don't understand how these just aren't contracts of adhesion.
Well, Your Honor,
we all do it, but does that make them not contracts of adhesion?
Well, a contract of adhesion can be enforced and is frequently enforced. So I don't think that nomenclature, whether it's accurate or not, sort of answers the question with respect. I think the question is whether a user, in this case, you know, the Kauders here, any Uber user, is put on notice, inquiry notice, constructive notice, that they are in fact going to be subject to these terms and conditions. And the question of whether they've been put on such notice is one that the court looks at in the context of the entire transaction, from the objective standpoint of a reasonable user, and as to how the terms are identified and available to be
So now what do we do now that we have Cullinane telling us that, you know, this is not notice, no notice?
Well, so the Cullinane decision, we believe, is wrongly decided for several reasons. Allow me to articulate a few of them. The first is it elevates the conspicuousness concept. It imports that into Massachusetts law, first of all. It's not found in Agemi, and it's not a feature of Massachusetts contract formation law in any case that I've seen or any case that's been cited in these briefs. And it suggests that it elevates form over substance in the sense that it suggests that somehow the notice that is provided on this very uncluttered record appendix 47 has the screen reproduced for the court. It's a very uncluttered screen. It suggests that somehow the box indicating terms and conditions must be blue in order to place a user on reasonable notice. There's simply no requirement for that sort of fly specking of the user interface when you're making the determination of whether somebody is on reasonable notice that they are entering into a contract. And again, I point the court to the Meyer Court's decision in the Second Circuit, which evaluated a very similar user interface for Uber, although a user interface that the district court in Meyer indicated was more cluttered and more confusing than that at issue in Cullinane, and indicated that in light of the nature of the transaction there and the way in which the screen is laid out, users are put on constructive notice that they are entering into a contract when they proceed through this process and create an account. And so I think the Cullinane decision is simply wrongly decided on the facts.
Okay.
I suggest this court needn't follow it.
Thank you.
How is the, I'm sorry, I'll get to you just slowly. How is the user supposed to know that the box is clickable?
Well,
Because I mean, usually hyperlinks are indicated with a different color. Here it just says subject to terms and conditions in a box. But I guess, are you relying on the sophistication of people who sign up for Uber, or there could be people like me who sign up for Uber who are less sophisticated?
We're certainly not relying on anybody being more sophisticated than a reasonable consumer. I think the underlining and blue color is a feature of hyperlinks that existed probably 10, 15 years ago. And as the Chamber of Commerce brief noted, and we cited some of the sort of standards for programming, boxes like this are increasingly commonplace, very commonplace, particularly in smartphones, as indicating that you can click on that and obtain more information. And so it's an objective standard that the court applies, of course, of the reasonable user. But we think the reasonable user who operates with a smartphone has gone to, here it's the App Store because it was an Apple phone, as the record indicates, downloaded an app and gone through the process of signing up, understands what the different layout of a screen like this entails.
Of course, you made a business decision not clutter your screen. You could have added text, you could have put a subscript that says click on for further information, but that was a business decision made by Uber, easier, correct?
Well, I think the more information that you put on the screen, the potentially more difficult becomes for a user to understand what's being communicated. I think the uncluttered nature of the screen here, which is relied upon by all of the other courts to consider this particular Uber interface, Meyer, the West Court, the Johnson Court, all cited in our briefs, the fact that it's all one page, no scrolling, as a part of a commercial transaction, this is the point in the process at which you're entering your credit card. Right, you're agreeing to enter into a forward-looking relationship with Uber where you'll use the app to try and request rides from drivers. The entire context of the transaction is one in which a reasonable user is going to understand that as a part of this arrangement, terms and conditions likely apply, and the notice is provided right there in the center of the screen. Your eyes really can't miss it as you're entering in credit card information.
It's one thing to alert people that terms and conditions apply. Certainly another thing is tell people, if you want to find those terms and conditions, you click on this button.
And I'd submit that's precisely what Uber's interface does. It says by creating an account, you agree to the terms and conditions, and the box is recognizable as the type of box that you click to follow and get more information. And indeed, as the record shows, if you click on that, you're brought to another page where you can review the terms and conditions if you choose. There's nothing to suggest here that the Kauders did or did not do that. But again, that's not required in order to form a contract. What's required is that it be reasonably communicated and accepted, and we think that's shown here.
Justice Chloe?
Sure. Ms. Ellsworth, let's use the term reasonably communicated as opposed to conspicuous for the purposes of my question. So if you come into the Adams Courthouse and you want to use the guest internet, you have a provision that comes up that lets you know about what's involved. And before you can get on the internet, you have to do one more thing. You have to hit accept. So that's easy enough to do. When we're looking at reasonably communicated, let's just assume that's a Jamian, instead of conspicuous. Why isn't it reasonable when you have a situation like this, especially if it's an adhesion contract, to just require that one more click on the hyperlink?
Well, Your Honor, I guess I'd respond in a few different ways. The first is I think there are two different steps here. There's whether the existence of the contract and the accessibility, the ability to review the terms is reasonably communicated. That I think relates to how the screen looks and the appearance of the link to go get the terms and conditions. And then there's the question of whether it has been accepted. And as the Ajemian court noted, and a variety of other courts have also concluded, some affirmative action of accepting indicates sort of a manifest intent to accept the contract. But that action doesn't need to be, I accept. It is, the Ajemian court says by—
I'm not asking you about whether or not they assented to the terms. I understand prong 2 of the analysis. And I'm not asking about prong 2. I'm asking you about reasonable. And considering all of the questions Justice Cipher asked about the screen and cluttered and the nature of how often we're doing this, why don't we infuse into reasonable that you are able to have something that you can click on as to prong 1?
So if I understand the question, Justice Lowy, the suggestion is that we should have to click and actually review the terms in order to be viewed to have accepted them. And I think that that's simply not required. It wasn't required in the time of paper contracts. I would point the court to the analysis in the Fteja v. Facebook case, which is cited in Ajemian, which makes this analogy to the Apple stand, and you can turn over the sign and look at the terms and conditions if you choose. It's constructive notice.
That's going to whether or not it was assented to. Your answer is addressing whether it's assented to. Justice Cipher's questions went to whether or not the way the screen appears in order to know what you're doing, whether it's conspicuous or whether we want to call it reasonably communicated. You know it's reasonably communicated if you have to do something that shows that it was communicated.
And here I think that we have. I think that the Uber interface that shows this box that you can look at or not as you see fit reasonably communicates to the user that there are terms and conditions that apply here. So again, I take your question, and I understand that whether it's called conspicuous or prominence or sort of any other phrase that we might use is neither here nor there. The question is whether it's reasonable, looking at this screen with 24 words on it, with this box in the center of the screen, to understand that a user has been communicated that there are terms and conditions that apply. And again, I would just point the court to the West decision, the Meyer decision, the Johnson decision, all of the other decisions looking at the Uber interface, at very similar interfaces to this one, and concluding under the contract law of other states, but all of which contain the same prong 1 and prong 2, reasonably communicated and accepted standards, that is a reasonable communication. And I would also just step back and remind.
Before we continue, are you finished your question, Justice Lowy?
No, I don't have anything else.
Okay, we have questions from Justice Kafka and then Justice Plank in order of hand raising. Justice Kafka?
What do we make of the fact that with the drivers, there's an elaborate agreement process, and with the users, there's no, as Justice Lowy just pointed out, no formal requirement of hitting the word agree or accept. So what do we make of that?
So, Your Honor, as a point of clarification, the record doesn't actually show what the driver process is. I understand an amicus brief was put in that suggests what the driver process is, but I don't think the court has before it credible or competent information about how the driver sign-up process unfolds. But putting that to the side, we do have a requirement here that users have to manifest an agreement. It is clicking done, and they're being notified that by taking that action, by consummating their attempt to create the user account, they are agreeing to the terms and conditions. So whether we call it the notice or the warning, the statement, by creating an Uber account, you agree to and then the box of terms and conditions. They're notified that by going through with this process, in fact, they're agreeing to those terms. So there is an affirmative act of acceptance here. And that's what, again, the other courts to consider the Uber interface have concluded, but also courts in a variety of other online commerce contexts have concluded that not just I accept is required. We have sign up, place order. There are other words like that where an affirmative act is required to be taken that isn't just clicking I accept or I agree. And that's sufficient to manifest the assent.
I don't think that sort of the average, the reasonable user out there doesn't think they have to hit a I agree anymore. I mean, when you sign a contract in writing, you're manifesting your assent somehow. And most of us are used to the internet, but we really do have to write. We usually do hit I accept the terms. I mean, at least that's common experience. You don't think there's anything sort of clever about the way this is done where you don't have to hit I accept the terms?
I don't, Your Honor. I think there are a large number of examples where you don't have to say I accept or I agree, and that contract is deemed to be formed. I've got the Stark versus Guilt case, the Facebook case that I cited earlier. There is a Beachbody case, Crawford versus Beachbody. All of those have a contract being upheld using some affirmation that's different than I accept. And closer to home, I would point the court to the Ajemian decision.
I'd like to switch to the procedural issue quickly, because I
Yes.
don't understand why. I mean, a judge has to be able to revisit a mistake. Now the judge may have to revisit it within the 30-day requirement, but I don't, you're saying the judge has a one-time decision. And that doesn't seem right to me. Couldn't the judge during the 30-day period have said, I got this wrong? I mean, if someone had asked the judge to reconsider within 30 days, wouldn't that have been appropriate?
Well, I think there are two responses. First of all, the 30-day period here, of course, the Kauders missed, and so that's not this case.
Right.
The judge might have a right to reconsider maybe before the arbitration hearing had commenced. There may be a point in time at which reconsider.
That can't be right, can it? If a judge decides he or she is wrong, they've got to be, I mean, I don't know if they can revisit it after the 30 days, but a judge can't get a one-time, there's nothing in the law ever that a judge can't change his or her mind, is there? I've never seen anything like it in the law anywhere in the universe.
Well, I'd point the court to the statutory structure of Chapter 251. I think it's quite clear. It says you can challenge either before an arbitration under Section 2 or Section 12A5 if you have not filed a challenge to the existence of an agreement to arbitrate pursuant to Section 2, then you can seek to vacate on those grounds. That's the statutory structure that's set up by Chapter 251. But in this case, after the motion to confirm had been filed, at that point, the judge really did not have the ability to reconsider this order compelling arbitration. It's almost like the filing of a notice of appeal.
I get it that he may not have the ability after the 30 days is expired, because we want arbitrations to be done quickly. And the plaintiffs may have been required within the 30-day period to say, look, I'm appealing your I'm saying you're wrong, and I'm appealing your decision within the 30-day period and then moving forward. But I don't see why the judge can't only get to one-timer. But again, that's all I've got. Thank you, Justice Gaziano.
You're welcome. Justice Link.
Yeah, I wanted to return to the subject of the adhesion contract. How do you, maybe you could educate me about what it is that it makes an adhesion contract enforceable, because you say some of them are and some of them aren't. I'd like to know what it is you think makes an adhesion contract enforceable and when it's not enforceable. And secondly, I'd like to talk about the question of whether or not accepting the terms and conditions is really all there is to it. Do you have to look at the terms and conditions themselves to make sure that they're not ridiculously oppressive? For example, I mean, you know, you could have a contract nobody looks at. The terms and conditions could be that you give me your firstborn child, and nobody would enforce that. So, I mean, is it a question of what do we look at to determine first of all, whether it is a contract of adhesion, and then secondly, if it is, what makes it enforceable?
Well, what we look at as to the first question is whether the user has the ability to accept or reject the contract. And here the user has the ability to do that. They accept the contract by registering and clicking done. If they choose not to accept the contract because they disagree with the terms and conditions, or they don't want to be bound by the terms and conditions, they press cancel. They don't register for an account. They don't avail themselves of Uber's service or of the right to use the app, and they've moved forward. I think whether something is a valid contract that will be enforced by the courts, again, goes to this question, the two-pronged reasonable communication and accepted. That's what this court needs to look at to determine.
And it doesn't matter what the terms and conditions are, in other words. It doesn't matter what they are.
Well, first of all, nobody has ever argued in this case that
I want to understand what it makes it a contract of adhesion.
I don't think
terms and conditions isn't not just a question of whether you can accept the terms and conditions, but whether they are reasonable terms and conditions, right?
Right. Well, if the terms and conditions are unreasonable, a court can, as the Superior Court did here, sever certain of those aspects as contrary to public policy, which is a decision that Uber did not appeal here. There's a portion of the arbitration clause that was severed before it went to the arbitrator, and that was based on the severability provision in the arbitration clause. So there's never been any suggestion that there is a problem with the terms and conditions here. But I do think it is not required for anybody to have ever reviewed a contract to be bound by it. If they have manifested the intent to be bound from hundreds of years ago, that doesn't mean that they have to understand the terms. It doesn't mean that they have to have even read them. And the rule shouldn't be any different simply because it's an online contract or created through a smartphone than it was in the cruise cases from 20 to 30 years ago, or much further back, Williston on contracts, et cetera. So it's not an argument that's been raised here. It's not an argument that we think would apply to the terms and conditions in Uber's contract, which is in the record here. But the fact that a user might not have read or understood the contract that he or she is agreeing to is not a barrier to enforceability of that contract.
Any further questions for Ms. Ellsworth?
I just have one quick question, and that is that one of your arguments is that if we rule in favor of the plaintiffs, there will be uncertainty in the legal market of contracts. There will be all this legal uncertainty. But don't individual people experience that legal uncertainty now?
Allow me to answer the question in this way. I think the requirement that a contract be set out in a particular color font or in a particular manner in the way that the Cullinan Court laid out and that the Superior Court accepted or adopted here does create, we think, significant uncertainty about the enforceability of a large swath of contracts that exist today. And we think that is a problem, and that's something the court that should not wade into or should not create. As to whether there is uncertainty for consumers and users today about the contracts, I go back to the core principles of contract formation. If users are put on notice that what they are doing is going to subject them to terms and conditions, as we all are almost every day as we engage in these transactions, then the users are bound by those terms and conditions. They can choose not to engage in the in the transaction or the relationship if they don't want to be so bound.
Sure. And we agreed not to be bound by Zoom today. I'm finished. Thanks.
Okay, thank you, Ms. Ellsworth. Mr. Needham.
Good morning. May it please the court. I'm Paul Needham. I represent the Kauders. And to start with, I want to deal with the issue of the motion for reconsideration. This was a motion, and before the motion for reconsideration, the judge did a number of unusual things. First of all, when he looked at this contract, he struck the liability. There was a limitation of liability clause. And what he said about it, it was the instruction to the arbitrator to deny all legal
Could you
relief.
talk a little louder?
Yes, my microphone, I am, I'll try to take it up a notch. The judge said with regard to striking the liability limit that was enforced in the contract, that the instruction to the arbitrator to deny all legal relief could hardly be clearer or more encompassing. The arbitrator, under the fine print of this contract, could not award any damages whatsoever. So that's to start out on kind of the ultimate contract of adhesion. So he did that. That's one of the things that he did. And the other thing that he did is he retained a certain amount of very unusual control over the case because he was very troubled by this. He said it was a close call and that he remanded it to arbitration reluctantly. And so on a couple of occasions, on the 31st, and this is in 2017 of August, he said that he was retaining jurisdiction in case there was further litigation. And again, on December 7th, he said the court defers any action that may prove necessary to preserve the plaintiff's rights or to successfully obtain relief against the provisions of the agreement that violate law or public policy. And he found also that there was a violation of public policy because there is a criminal statute, 272-98A, that makes it a crime not to pick up somebody in a public conveyance that has a guide dog. And not once, not twice, but 3 times, Uber failed to pick up Mr. Kauders. So these things all went into the mix. Then, so it goes to arbitration. We had no choice. We were the plaintiff. We had no choice but to go. We made all sorts of objections. And when we came back, it's rather interesting. The arbitral decision was the 4th of June, 2018. 21 days later, Cullinan came out. And then in that fall, we were before the judge opposing their motion to confirm the arbitration award. And the judge said a couple of things. He said, first of all, I relied heavily on Cullinan in my first decision, and Uber relied heavily on Cullinan, and Cullinan is now flipped completely.
Right.
Counsel,
may I interrupt you now? I read the transcript that you're referring to, and I've read Judge Wilkins' considered memo. And I suppose what I need you to do for me is to address the question, the specific question of this 30-day limitation. And I understand the argument that if there's no if it's an invalid arbitration agreement, perhaps the 30 days doesn't apply at all. But if we're stuck with this 30-day limitation in terms of your motion to vacate or your motion to dismiss, rather, how do you win on that? How do you get around that?
well, I don't think you're stuck with the 30-day limitation, or we're stuck with it, unless you can show a valid contract was created. Unless there was a valid contract where no strictures of the FAA or the MAA is going to control under the circumstances. And what we have shown, I think, in this case rather clearly, is there wasn't a valid contract, not according to Agemian, not according to Cullinan, and not according to the Theodore cases and other cases that followed in the federal district court. Because if you look at that, it's very clear that you have to contract this away. We have a 7th Amendment right to a jury trial. If it's contracted away, the court takes a close look at the contract, and whether there's no question it's reasonably conspicuous notice or reasonable notice. We had neither. And then you have something called an unambiguous manifestation of assent, and that wasn't here either. So my answer to your question, Justice Seifert, is that if there is no contract, there is no arbitration, there is no obligation to have a 30-day rule. And we think we've shown rather clearly that there wasn't a contract. And,
Thank you.
And you come to that conclusion by looking at the screens. And here we have 3 screens. Yes, Justice Kaplan.
We've been reversed and rebuked by the U.S. Supreme Court a number of times for not enforcing arbitration agreements. So we enter into this area where we've got to be cautious. So I'm troubled unless, and Culline's not binding on us. It's a First Circuit decision. It's not binding. So teach me, why we should not find the acceptance here reasonably communicated, and the provisions not reasonably set out. Because when you use the service, you sort of, I looked at the supplemental appendix, and we haven't ruled on whether this is proper or not, but on one page, you look at it and it says, by using this, you accept the terms and conditions, right? It says that right up front.
It says that, but what's hopelessly confusing about this, and the reason there is not a contract and there's not a valid acceptance, is there's 3 screens. The first screen is called create an account. Second screen is called create a profile. Third screen is called link payment.
You don't get to use Uber unless you get to the 3rd screen and fill it out. The first 2 screens are warm-ups. They don't mean anything. You got to get to the 3rd screen or you're not using Uber.
That's correct. And you have to push done on the 3rd screen. And
Right.
there's no blue underlined hyperlink. And we all know, when we logged on today, we looked at Zoom meeting, and everybody knows you go to the blue underlined hyperlink. And there was such a hyperlink in Meyer when the Second Circuit said it passed the muster. There was no blue underlined hyperlink. There was a real confusion here. After you put your credit card in, you could push done. It didn't prevent you from pushing done. It didn't say, by pushing done, you have accepted these terms. It was just done as if you were done with the financial transaction.
You think a reasonable user who's done this doesn't think they're bound by the terms and conditions here, given the way that screen works? You think that they get to use it, but on their own terms?
I don't think so under contract law, because this is what we're talking about, formation of a contract. And so there's a burden on the person enforcing the contract to show that this was a reasonably conspicuous notice and there was an unambiguous distinction.
The conspicuous point, I don't get. I don't know where that comes from, because isn't it connected to forum selection provisions, which are held to higher standards? Have we ever, or has the U.S. Supreme Court required conspicuous arbitration language?
Well, I think if you look at this, if you look at the forum selection in cases like a Jimmy, and this, they announced a standard. It wasn't specifically for shortening the statute of limitations. It wasn't specifically for forum selection. And when you look at this screen, and keep in mind, this was a very different screen in Meyer. And Meyer showed you, I think, what the minimum standard is. Meyer, there was a hyperlink. Meyer, and there was a thing that they called physical proximity and spatial coupling. There was a bar or a button called register, and right directly under it was the hyperlink. Here, there's no hyperlink. The statement about terms and conditions is at the bottom of the page. It's called link payment. You have a little box called done right up after you put your card in, you push done. And what's more confusing here is the first screen was called create an account. So it's quite possible you could be looking at this saying,
Okay,
create an account.
I have one last question, Mr. Needham, and I'll defer to my colleagues. Why weren't, my understanding, at least in the MCI telecommunications case, First Circuit, again, we're not bound by it, says that when you participate in arbitration, even if you're sort of dragged into it, you still are bound by the 30-day rule. why shouldn't we require you, Cullinane was decided within 30 days. Why shouldn't we require you to appeal within 30 days? Meaning, tell the judge, you got it wrong. The arbitrator, why don't you preserve your objection within 30 days, and then you can take this up on appeal. But if you let it sit longer, you've violated the Arbitration Act.
Well, the whole basis for the motion for reconsideration was a couple of things. It was the Cullinane case, to be sure, and the arbitral decision was the 4th of June in 2018. Cullinane was 21 days later, and then we were in August when they were confirming arbitration. And that's when we learned for the first time that the judge was saying, you briefed the Gemian initially in June of 2017. I failed to properly consider it. And that is the basis of a motion for reconsideration. He failed to properly consider it. And so I think that motion for reconsideration is a determination that there was no contract in the first place. And therefore, I don't believe we're bound by the 30-day rule. Because this was, these facts we did not become aware of these facts until we had a meeting with the judge, a hearing on October 25th. And he announced that if you read the transcript, and then that was the January 2019 opinion. So I don't think that we were bound by the 30 days under the circumstances. And I think when you look at the screen, this screen, obviously the gold standard is I accept, you have to scroll down. But here, when you say done, it's not, you don't know what's being done. You don't know.
I think you're circling back from the question to the substantive. Let me now turn to Justice Lowy, who has a question.
I'm sorry, yes, Justice.
So, Needham, I share Justice Kafka's concerns about the Federal Arbitration Act and whether the Act preempts state law when the state law is providing some sort of enhanced contractual protection in the context of arbitration. And the issue is whether the conspicuous requirements that's sort of imported in from the Forum Selection Clause, a Jamian circumstance, is really singling out arbitration agreements under Massachusetts contract law in a way that, as Justice Kafka says, is going to get us in trouble again because the Federal Arbitration Act preempts state law when you're in a situation where the state law has enhanced protections for arbitration clauses.
Well, first of all, if there's no contract, and we believe that Judge Wilkins showed very clearly there is no contract, there is no federal arbitration law, there is no federal preemption. That just doesn't.
That's sort of the circle, though. He assuming in my question is that conspicuous from Forum Selection Clause sort of adds to the requirements for the meeting of the minds when the contract involves arbitration.
Well, I think whether this is conspicuous or reasonable notice or reasonably conspicuous notice, I don't think this makes it under either circumstance. And as far as going to the arbitration, this was brought up, we had no choice. We were the plaintiff. If we didn't go to arbitration, we had no right to appeal. You have a right to appeal if the motion for compel arbitration is denied, but if it's allowed, you have to go. So we had no choice. We protested, we went there, and I think subsequently with the Cullinane case, coupled with the judge's rather frank assessment that I failed to consider this, you can't override a judge on, and one of the cases called it, this was a judgment on the road to final judgment. A judge cannot, when he looks at it, says, you briefed it, I missed it, I'm reconsidering it, and he went back, and I think he has a discretion to do that, and he determined that there was no contract, and I think that it means that there is no applicability to the 30-day rule. I think that's the response. So I think that for the court, I think to rule in our favor if the court rules, and I hope you will, that no contract was created because it wasn't conspicuous and there was no manifest assent. It's a very confusing screen, no hyperlink. If you reach that determination, then there is no written arbitration agreement. There is no.
You had a choice, right? You could have refused to go to arbitration. Justice Wilkins can't make you go to arbitration. You could have refused to go and appeal Justice Wilkins' order, couldn't you?
You can appeal. It says it says there is no right to appeal, and the appeals court tells us all the time, no interlocutory appeals. And he said
you can just refuse to participate in the arbitration altogether, and then when they issue the award, you can appeal it, correct or not?
If Uber's not going to ask for, if we don't ask for arbitration as the plaintiff, Uber's not going to do anything. Why should they bring forward? And so we're left without a remedy. We had no choice but to do what we did. We objected as much as we could. We have no right to appeal. We have no interlocutory appeal because we don't have a final judgment. And Uber, I can't speak for Uber, but Uber would make no sense for Uber to go to an arbitration. We're the ones looking for the relief. We're the ones that had to ask for arbitration, and that's why we did it. We felt we had no other option. And I think that your honors can reach this conclusion that it's clear that there are a lot of options available to Uber. There's hyperlinks they could have used. There's the gold standard of a click wrap.
You have a case that says, if you say Judge Wilkins gets this wrong, that this is not subject to arbitration, and that there is no way, you are absolutely forced into the arbitration process. You can't appeal that. You can't, because we have a lot of cases where we've got people challenging the arbitrability of issues. So tell me which cases I should look at that says you're stuck following that order, going in through the arbitration process.
Well, we looked at 251, and it says you don't have a right to appeal. We have the appeals court always saying, I don't know whether it's 231, 108. We don't like piecemeal appellate litigation. Come back and see us when you got a final judgment. I don't know how many times I've heard that from the appeals court. And so, and to just correct one thing, I didn't say Judge Wilkins was wrong. Judge Wilkins said that he was wrong in a very candid assessment. And I think he has discretion under those circumstances. And I think if the court is concerned about treading too much on the FAA, well, treading too much that I'm concerned about is a judge, a trial judge, with on the road to final judgment, with decides a reconsideration based on some changed circumstances, that he doesn't have discretion to do that before final judgment. That's the point that we want to make, and we think that's an important point.
Mr. Needham, let me ask you, do you believe that the reasonable user experience evolves as technology increases?
Well, I sometimes do, but some days with myself, I think I get more confused rather than less confused as time goes on with, because there's always a new change. There's always, you're considered a little backward if you're looking for a hyperlink.
Right. You put your finger on the point I was trying to ask you about, because if we say, you need a blue hyperlink, and the response from Ms. Ellsworth is, that was the flip phone era. We're now into the smartphone era. Do we run the risk of shortchanging the technology and doing damage to this vital part of the economy if we say, in our old stodgy opinions, unless there's a blue hyperlink, you're out of luck?
Well, even with, if they're buttons instead of hyperlinks, and the button passed muster and mire because they said that there was this spatial coupling, this physical proximity that was put underneath. And if we all logged onto Zoom tomorrow and there's no hyperlink, there's some kind of box or some kind of description.
What if there's a whole bunch of 20-year-olds who are watching this and are giggling because they know darn well that a blue box means that you click it?
Well, I think that regardless of the technology, and this is a bit of a hypothetical question, they've got to make it clear and logical if they can. And there's so many instances where it would have been very easy for Uber to solve this problem by saying you can't push done until you click on the terms and policies and say accept. And to be clear that by done, you are acknowledging that you have read this. There's no connecting the two. This done is consistent with several different things. They didn't make it clear, and therefore I think that they have violated their right to be to make it as clear as they possibly can. And it's a formation of contract. We're going back to the formation of contract, state law. Judge has discretion. The judge has discretion in a motion for reconsideration, and that's our argument. I think it's a very sound argument, and I think that this, and take a look at the screens, and if you see how confusing they are, they could have made it clear, they could have made it much better. They didn't, and they have to bear the burden.
Any further questions for Mr. Needham? Thank you, counsel.
Thank you.
Your Honor, I'd like to seek the court's permission to submit a letter pursuant to Rule 22C2 to address some of the points Mr. Needham made.
You certainly have that ability.
Thank you very much, Your Honor. Thank you all.